Everyone, I'd like to remind you just to turn off all your noise-making devices, particularly your phones, due to the live stream, so any audio and video, take that out. So everyone can see. All rise. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. We are here for oral argument in cause number CV180572, City of Glendale versus Vieste, and I might be pronouncing that incorrectly. If I am, please let me know. SPE et al. These proceedings are being audio and video recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes to complete their argument. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if you desire. Also, we have read the briefs, we have discussed the case in conference, and are familiar with the factual background, so please consider that in making your presentation. At this point, counsel, you may proceed.
Good morning, may it please the court. Rob Carey for Vieste,
Vieste.
the appellant. This is a contract action that revolves around whether yard waste was acceptable waste for a $30 million waste processing facility that, at least at the time, the relevant times, could not process yard waste. And the answer to that question is no, it's not acceptable waste, and the trial court erred for three basic reasons. One, there was a binding arbitration that decided the issue against Vieste, or against Glendale, with the force of res judicata. Second, the contract's prohibition of yard waste in Exhibit B cannot reasonably susceptibly be construed to mean that yard waste of one type is acceptable, but yard waste of another type is not, especially when the distinction is about what truck it was put on when that's made by the resident, that decision. Third, extrinsic evidence proves that the phrase yard waste covers all yard waste, or at least raises a question that should have gone to a jury. But at bottom, what is going on here is the city decided to go into the arbitration and admit that yard waste was unacceptable because it believed, its defense was, that it did not have to sort the materials presented to the waste facility. It then filed that lawsuit in the Superior Court, realized that wasn't going to work out for it, and then doubled back and tried to take a second bite at the apple of what the arbitrator had already decided against it, that yard waste was unacceptable.
Counsel, what did the arbitrator decide?
The judgment from the trial court, based on the arbitration award, was that yard waste was unacceptable.
And who helped the arbitrator decide what the scope of that ruling would be?
The parties.
And
they had...
as a practical matter, what did it decide, other than state the plain language of the contract?
Well, you have to consider also, remember, it's a judgment, so you're going to construe it as if it were a trial court judgment, that you look at it and say, what did it decide? And you have to take into context that...
It's a stipulated judgment.
Well, sure, but it's still a judgment. It has the full force of res judicata, whether stipulated or not. But the issue that was presented to the arbitrator was that municipal solid waste had yard waste in the same bin. That was the dispute. That's the fact context before the arbitrator. The city said, we don't have to sort it. They argued the composition of it. They argued all of the things that that are arbitrable under the agreement, which would be the composition of the waste and the acceptability of the waste. They argued
Understood.
all of that.
Understood. Why weren't those things decided?
Well, the judgment was that yard waste was unacceptable,
Which means what?
which means that you can't, in that
Which means
context.
who sorts it?
Sorting's a different issue. We're not contesting that sorting is part of that judgment. What we're contesting is you can't go back and say yard waste that sits next
So you're
to.
saying that ruling, the arbitration ruling, resolved all the parties' problems. There's no issues. The parties were supposed to just go forward, towing the line under the terms of the agreement.
Well, what I'm saying is the issue of whether yard waste that is blended into a container that has municipal solid waste cannot be relitigated as to whether the yard waste is unacceptable or acceptable.
And how was that relitigated? Because the trial court said it wasn't disturbing. Didn't Judge Bergen just specifically say, I'm not disturbing that ruling?
Well, sure, but her first issue on the interpretation of the contract is yard waste acceptable if it's in MSW? That's essentially asking, is yard waste acceptable in a specific context?
Wasn't, in fairness to the court, isn't the court accepting the view that there's more than one reference to yard waste in the contract? I mean, let's talk about organics. Let's just jump into the.
Sure.
How do you explain why in municipal solid waste, why is there a definition of organics? Or what's the purpose of having organics, parentheses, wood, yard, and food?
Sure.
Why did the parties put that in?
The parties put it in there. It was put in as a little subset of municipal solid waste. So you have to go back to 1.1.54, which is the definition of waste in the parties' agreement, the WSA. That breaks out that MSW and yard waste are two different components. So both of those get carried over to Exhibit B, put in separate headings, and under MSW they add organics, yard, parentheses, yard, wood, food, right? And then you have a separate category of yard waste. So the question is there yard matter that is not yard waste? And the answer is clearly is yes. Everything in a garden would be, vines would be, ground cover would be, all plants would be, all flowers would be, citrus, apples, anything from a garden would be yard organics. And the point is, if you're going to break out yard waste, which is a separate category in the definition of waste from municipal solid waste, then you have to say you have to try to construe yard organics to be something other than that. Because if you construe yard organics to be anything that comes out of a yard that's organic, it basically eats away not only Exhibit B's use of yard waste, but it eats away the separate categorization in 1.1.54 that yard waste is a separate category from MSW. So instead of saying, how do I harmonize these two and read yard organics to be things other than yard waste, assuming there's a category, and there clearly is, the trial court basically said it's an unresolvable conflict without trying to harmonize them. And her harmony was found by saying, I'm going to adopt the city's approach that it's only on the days you pick up bulk waste.
There's more provisions that need to be harmonized, right? Aren't we trying to harmonize the whole contract, not just these two?
Well, once you harmonize that yard waste has meaning unto itself, and that
I'm still not understanding what you're saying is the definition. What is included under organics?
Citrus.
But was your client willing to accept organics?
Yes.
Citrus fruit. Wood.
Apples.
It says
produce.
It says wood.
Absolutely.
What kind of wood?
Wood incidental to residential collection. It has to mean something other than.
Could not accept those as part of phase one.
Well, that's just not accurate, Your Honor. In fact, post dispute, our client sent the proposed procedures that basically said they'd try to accept.
Back up. You rejected 320 or over 300 loads.
Correct.
What did they have in them?
31% yard waste, on average.
So yeah.
Keep going. Jump in.
I'm confused. Okay. This all has to do with the definition of capital yard, capital waste versus organic waste. When we talk about citrus can be in there, yard clippings not in there? Yard clippings
Well,
in
yard
there?
waste is very specific. It comes from three areas. It comes from shrubs, trees, or lawn. So anything in a yard, in a residential lawn that comes out of there would not be yard waste by definition.
Okay.
So, produce, pine cones, cranberries, cran apples, all of those things are either anything out of a garden, anything out of an herb garden, flowers. Those would all not be part of yard waste. Yard waste was designed to capture the yard waste collected by a homeowner in doing yard work. That doesn't mean it's organic yard material. And so the issue is there something that's left in a gap after yard waste that comes out of a yard? If the answer to that is yes, then that's what yard organics has to be.
So let's just take this down to the basic, because garbage is not my jam, so to speak. When I put my garbage in my garbage can, if I mow my lawn, I put my grass clippings in there, I put my kitchen garbage in there, my bathroom garbage in there. If I have fruit fall off my fruit tree and it's bad, I put it in the garbage. All of that is acceptable under the municipal solid waste definition, is what you're telling me.
No, I'm not. What I'm saying is if you go out and get shrub items that are clippings, trimmings from shrubs, lawns, trees, or you get branches or logs, things that meet the definition of Exhibit B under yard waste, if they meet that definition, they are not part of municipal solid waste.
So let's back this up to just, I need to wrap my mind around, and I admit, we've read the record, I am not a garbage expert. When the city of Glendale entered into this contract, yard waste was accepted out, but why would they agree to a contract that says they can't sort it before they give it to you, but they also can't give you grass clippings? Because I put my grass clippings in the garbage can.
Well, the contract
people
doesn't.
do.
Sure, the contract doesn't say that they can't sort it. It presumes the opposite. What they're saying is, their argument is they're not required to sort it. And our response is, that's true, you're not required to sort it, but you have to provide under paragraph 2.4.1, you have to provide acceptable waste. All waste must be acceptable as defined by Exhibit B.
But conversely, your client could reject all the unacceptable waste.
Yes,
It could
correct.
reject as much as it wanted to.
Yes, correct.
But don't we have some irreconcilable differences here?
Well, I don't know if it's irreconcilable, because it was pointed out to the city that, look, we're not going to accept yard waste during phase one. And if you look at our statement of facts, roughly paragraphs 75 to 100, we laid out we can't accept that waste. The plant will not process it. And the city, by the way, in its complaint, understands all this. This is where Judge Bergen's ruling goes off the rails, because the city says the parties, understanding that yard waste is unacceptable, which is all over their arbitration papers, by the way, the parties simply disagree on who bears the burden and cost of making the city's typical municipal solid waste stream compatible with Vieste's recycling plant's sorting equipment. And in paragraph 9, they say the parties have reached an impasse over who sorts the waste. They understand it's unacceptable. That's not the dispute. Their entire legal posture was to show up and say we don't have to sort. But the corollary of saying I can reject loads with unacceptable waste is, then you better figure out a way to get acceptable waste to us to meet your minimum, because you either have to change your bulk waste program so it's required that yard waste be put in there, go subcontract with another municipality, or go pick up collection sites that will only produce acceptable loads and bring those in. But the contract is crystal clear, and the correspondence between the parties is clear, that Mr. Brandeman said you cannot drop off yard waste to us. And they didn't do anything about it. That's what Mr. Brandeman said. Very little attention was paid to it. They circulated a document that laid that out, and Mr. Shelley, their lawyer, said, hey, we have to, yard waste has to be removed. And let me address what Judge...
Why didn't that make it into the contract? And if it didn't make it into the contract, what significance did it have?
Why didn't the fact that it has to be removed be?
Yeah, what Mr. Shelley's comment or suggested change didn't make it its way into the contract, did it?
Well, that's the city saying that. That's the city internally saying it to each other. And Judge Bergen excluded it from her interpretation of the contract and found that yard waste is indeed acceptable if it comes off of the bulk truck, or acceptable if it comes in the MSW. But the point of the email is not who has to remove it. The point is that they understand, it illustrates knowledge, that they understand that yard waste is improper, it's unacceptable, otherwise there'd be no point in removing it.
Isn't the converse true? Didn't your client know just as well that there was going to be up to 25 to 30% of municipal solid waste in every receptacle?
No.
Based upon the City of Phoenix study? Your client didn't know that. Had
No, they
idea.
understood that it was in there. That's why they raised the issue with the city to say...
They could have just said...
They did.
It has to be pre-sorted.
Well, it's not their job to figure out how the city should comply with the contract. But they raised the issue with them, Your Honor. They raised the issue that yard waste can't be in that stream. The city understands that.
And why define yard waste as delivered in lengths not more larger than 5 feet and a maximum 12-inch diameter?
Because
why
that-
does it so closely track the language track the monthly bulk waste?
Sure,
pickup?
because that exhibit has to cover phase 2 where that waste will be coming in, and that's the limitation of the system. So it has to cover that too. Those
Are
limitations.
you saying that this is actually clear?
No, what I'm saying
this
is-
whole scheme, this contract scheme? Because I read do you contend that there's no ambiguity in the contract?
I contend there's no ambiguity about yard waste, the phrase yard waste.
How do you, let's go back to the term wood. I'm trying to understand your point. If wood, does wood come from a shrub or a tree?
Well, a
Where
shrub
else-
is
where
a
else
shrub
could
is a
wood-
wood-based plant, but
Okay.
wood comes from other places, obviously.
So organics has wood in the
Mm-hmm.
parenthetical, but what does that mean then? Where could that wood possibly come from? If
Well, it
doesn't
could be
come
like-
from a tree or shrub.
It could be a pine cone, it could be bark shavings, it could be any number of things of wood. I mean, I don't understand. The
A
wood,
pine cone
the
is
only
different.
thing yard waste precludes is that which is collected in a concerted effort to do yard work. If you read what they have, the trimmings, the logs, all of that, it's really designed to collect your effort to maintain your property. If there's other things that are a byproduct of having a yard that aren't refuse collection, then it would be properly in the organic category. Again, let me go back to my point I was going to say about what Vieste tried to do after this dispute arose, where they said, look, you're bringing in 31% yard waste, we can't do this. They then sent procedures around that said, look, we'll try to take things without a majority of yard waste. They're not saying they couldn't take some with some small percentage and that they wouldn't go out and reject them all. What they said was, look, we'll try to work through this. But the city basically said, that's it, we're done. You have to take yard waste. But I want to go to the central point here that seems to be a problem, a hurdle here for me, of whether yard waste is acceptable or not. The city's position in arbitration and the city's position in litigation in all three of their complaints is not that yard waste is acceptable. That's Judge Bergen's finding. Their position is yard waste. The right Vieste has is to reject those loads, that it's acceptable and it's a sorting problem. They understand that the intent was to deliver compatible material to the facility. And the ruling of the trial court is essentially that not just that there's the rejection right, because that seems to be gone. When you say it's acceptable, Vieste has to accept these loads. There is no right of rejection. The right of rejection is to reject unacceptable loads. And so when Judge Bergen says it's acceptable, the rejection scheme is out. Their entire approach to this case, that it's unacceptable, but they can reject it, and we don't think they will. They went on the assumption that they thought that Vieste would reject it and that they were going to operate on the good faith and fair dealing. But that's not what we have here. This is eligible material, which contradicts the very introduction to their complaint, that the whole goal of the parties is to get compatible, acceptable feedstock to the waste facility. And that did not happen here. And it's an improper reading of the contract to have a construction that's directly, diametrically opposed to what they say the intent of the parties was in their complaint.
Let's go back to the intent of the parties and put the complaint aside. I'm at the very inception of this process between the two parties of negotiating what's going to happen. If the city was aware that 30%, up to 30% of all of their municipal waste contained yard waste, according to your definition, and the city billed this to the city council that it was going to have absolutely no fiscal impact on the city and that there was no risk to the city in entering into this contract. That's what this was billed at, as far as I can tell. If they were aware that there was 30% yard waste and knew they would have to sort under this contract based on your definition, why would they have entered into the contract in the first place?
Well, the risk that, I think this has been adequately briefed in the record, not on the appeal, but in the trial court record, the risk is talking about the building of the plant. There's risks both way on what happens and how this works. That if they have loads rejected, they have to take them at their expense and put them in the landfill.
Which was a sunk cost for them anyway, because they were taking it directly to the landfill.
Well, it's not a
correct?
sunk cost because you have to redo it. You have to come back and
Okay.
get it. So
It's a negligible
I'm just
cost.
saying, the things switch. But when you say, let's go, look, we got this plan, and we have to have this first phase that can only be recyclables, and we can't use yard waste, and they agree to it, and they all go, okay, let's do it, that's what we're going to do. You split it into it, and they say yard waste doesn't work in this first phase. They put out a document that says don't bring yard waste, and then they bring yard waste, knowing again, agreeing that it won't work in the facility. And so you ask, what should we have done? We raised it with them, circulated a document. Their lawyer understood that it had to be removed, which indicates that it's unacceptable waste. So, I mean, I don't think the cost can get in the way of an admitted intent to have feedstock that works with the facility. And with that, I'd like to reserve my remaining time. Thank you.
That's all.
Good morning. I'm Cindy Ricketts with Sachs Ricketts & Case, and I represent the city of Glendale. And with me here today is my partner, Nathan Coons, and our client, Michael Bailey and Nancy Mangone. Mr. Bailey is the city attorney, and Ms. Mangone is the assistant city attorney. I would like to address first why this trial court summary judgment was right and why it should be affirmed in interpreting the waste supply agreement. And second, I will touch on the res judicata issue that Mr. Carey raised. As an initial matter, I feel the need to correct something that Mr. Carey consistently said to you this morning. He inferred, as does Vieste's appeal brief, that the facility, the Vieste facility, was constructed prior to the execution of the waste supply agreement. That is not factually accurate. The facility was constructed a year and a half after the waste supply agreement was constructed, and the recitals in the waste supply agreement support that because it discusses in the whereas clauses that Vieste will initially construct and a facility to both collect and, the language is, sort municipal solid waste. Turning to the first issue as to why the only issue properly before this court is whether the trial court correctly granted summary judgment. And that answer is yes, the trial court did, because the court did exactly what Taylor versus State Farm dictates that it does. The court first considered the text of the waste supply agreement to determine whether either of the parties' interpretations of the contract, that the contract was reasonably susceptible of either interpretation. And in doing that, the court concluded that only the city's interpretation supported, or only the waste supply agreement was reasonably susceptible of the city's interpretation. And then second—
Counsel, to what extent, let's just jump into the wording of yard waste, B2, section B2. To what extent did Judge Bergen clearly define or lay out what Mr. Carey was relying on, as far as everything in that definition needs to come from trees, shrubs, or lawns in the first sentence? Because it gives a list and it says from trees, shrubs, and lawns. So how is that not a comprehensive definition of what constitutes yard waste under the agreement?
Well, Your Honor, what Judge Bergen did is she looked at the waste supply agreement as a whole, and she did what she was required to do, which was to harmonize all provisions of that contract.
But before you even get there, don't you start with the plain language and stay at the plain language if you have to?
Yes, Your Honor.
If it's appropriate.
Yes, Your Honor, but Vieste's interpretation requires you to essentially find that both yard waste in Exhibit B, 1A, is both, and yard waste under 2A are both an acceptable waste type and a unacceptable waste type. And, Your Honor, the reason that the Judge Bergen harmonized the contract is because Vieste's interpretation would require the court to ignore both 1.1.54, which defines waste to include lowercase yard waste, in the very same way that in Exhibit B in 1A also defines yard waste. So it is important to look at also the fact that the way this contract was constructed, Exhibit B, it is intended to and does define two different acceptable waste types. And that's why there's a Roman numeral 1 that says municipal solid waste. And then there's an A, B, and C further defining the categories that fall under municipal solid waste.
Right.
And-
1A is what I've been referring to as the organics.
Right. And that is one aspect of what is included in the city's typical municipal solid waste. And exactly as you, Judge Campbell, referred to, that's what residents do, exactly what you do. They throw all of their garbage into their their container that's picked up curbside. They don't separate whether it's yard waste, they don't separate bathroom waste, they don't separate food waste, they don't separate any of the gardening items that Mr. Carey referred to this morning. And so what the parties knew, and this fact is undisputed, that prior to the time that the waste supply agreement was executed, both parties knew that 30% of the city's typical municipal solid waste contained yard waste. And that is what item number 1A in Exhibit B is referring to. It's referring to all of the yard waste that residents like you, Judge Campbell, throw into their container and is picked up curbside. What item number 2 under Exhibit B is referring to is capital Y, capital W waste, which is an entirely different type of acceptable waste. It is not included within the definition of municipal solid waste, item 1A, but is a separate category, and that category is reflective of the source of that waste. And this fact, the differences between these two different types of acceptable waste, was known to the parties from the inception of their negotiations. When this project first started, it was to be a renewable energy facility. And if you look at the MOU, this exact verbiage is included in the waste specifications definition. It is item number 1, A, B, and C, and also 2A. And that language was lifted from the MOU into this Exhibit B, and the only thing that was added when the parties decided to phase the project about a month before the contract was executed was 2B. And the reason that Vieste wanted this separate category of capital Y, capital W, which referred to the bulk yard waste that was collected by the city, both in a monthly pickup and also delivered to the landfill, is because when the facility was to be a renewable energy facility, Vieste wanted to make sure that the city delivered this yard waste that had these dimensions that corresponded to almost verbatim, the only difference being 5 feet versus 4 feet in the city's instructions about bulk yard waste. Vieste wanted to make sure that the city delivered that source of yard waste to Vieste so that it could be turned into renewable energy. When the project was phased, the parties agreed to add 2B. 2B meaning that the bulk yard waste, this source of yard waste, would not be delivered to the Vieste facility only during phase 1. Because during phase 1, Vieste didn't need that yard waste to convert into renewable energy.
You know, Council, I'm listening to your presentation, to Mr. Carey's, and you both seem to have quite different interpretations of the language in this agreement. Why was that not a question of fact?
Your Honor, it's not a question of fact because under Taylor versus State Farm, Judge Bergen did what she was supposed to do. She listened to the parties' differing interpretations of the contract and read based on both the text of the waste supply agreement and the evidence that she considered that the only interpretation that the waste supply agreement was reasonably susceptible was the city's. Because Vieste's interpretation would mean that provisions in this contract would have to be ignored. It would have to ignore the definition of waste 1.1.54, and it would have to ignore that yard waste is included in the definition of the city's typical municipal solid waste in 1A of Exhibit B. It would also require, Vieste's interpretation would also require the provision 2.4.1 in this agreement to be ignored, and that provision precluded the city from sorting its waste stream prior to delivery to the Vieste facility.
And I did ask Mr. Carey, are they prohibited from pre-sorting? And section 241 of the agreement says not to pre-process or otherwise segregate a stream of waste in any manner.
Right. What Vieste is asking the court and asked Judge Bergen to do is to read that language in 2.4.1 to mean something other than the express language that it says. Vieste precluded the city, and the city agreed not to change the composition in any material way of its typical municipal solid waste as it was collected. And as I said earlier, both parties knew that the city's typical municipal solid waste contained at least 30% yard waste. And so if the city was required to only deliver acceptable waste and sort out that yard waste, it would, by definition, be required to pre-process and sort out that yard waste, which was impossible given the fact that the city, as Your Honor, Judge Campbell recognized, the city council approved a project that would be of no cost to the city. And the other reason, Your Honor, that this isn't a question of fact, and the Judge Bergen got it right on a summary judgment motion, is that she considered the extrinsic evidence that the parties presented, both parties presented. And looking at this evidence, which she looked at the parties' negotiations, and she looked at the parties' course of dealings after the agreement was executed and when the parties attempted to operationalize the agreement and before the dispute arose. And she also looked at Vieste's extrinsic evidence. And looking at that evidence, both the parties' negotiations leading up to the execution of the waste supply agreement and the parties' course of conduct, she concluded, as was her right to do and as she properly did under Taylor, that based on that evidence, that the only interpretation of the agreement that was reasonably acceptable was the city's, because the evidence showed that, one, in the negotiations, that the parties both knew about the separate sources of yard waste, the curbside collection, and this bulk trash pickup. It understood that these were different sources. Vieste understood, the city understood, and based on that negotiation, beginning when the MOU was entered in September of 2010, the parties always proceeded through these negotiations, understanding these two separate sources of garbage.
Well then, what was the practical or legal effect of the arbitration decision?
Well, Your Honor, the practical effect was it was a waste of time. And the reason it was a waste of time is because Vieste wanted to keep it to a very narrow issue, essentially parroting the language in Exhibit B to what the language said in 2B.
But you agreed to that.
We
you
briefed
agreed to the scope of the arbitration question, didn't you?
We briefed the scope of the arbitration provision to Judge Meyerson. And Judge Meyerson and that's really what Judge Meyerson said, was the scope of, or the limited scope of what he did in his arbitration ruling, which was to rule upon what the scope of the arbitration provision. And it was the city who wanted to broaden the scope of the arbitration, but it was Vieste that wanted to limit the scope to this very central issue. And if you look at, and I'm looking at Vieste's position statement that was submitted on March 6th, 2015 to Judge Meyerson, and that's at EIR 24. And this is the issue, the sole issue that Vieste told Judge Meyerson that was before it. It says, this arbitration requires no further briefing, no discovery, no witnesses, and no exhibits beyond the waste supply agreement itself. The arbitrator need only read the agreement and resolve the question, quote, is yard waste an acceptable waste type under the waste supply agreement before the date on which the Phase 2 energy facilities are commissioned? That's the limited issue that Vieste wanted Judge Meyerson to decide.
Is that capital yard waste?
Capital Y, capital W.
So if the arbitration had extended to the scope of what is organics in the waste stream, that would have solved this issue?
I don't know, Your Honor, if it would have, but what the city wanted to do is have Judge Meyerson decide all the issues related to the interpretation of the agreement. But what Judge Meyerson found, and this is in both in his order itself and its ruling, and which is in our appendix at page 128, paragraph 7, but also when Judge Meyerson ruled upon Vieste's request for attorney's fees, he expressly stated the limited nature of the arbitration ruling. And I'm going to quote this. He says, "In reality, the dispute before me was more about the scope of the arbitration agreement rather than the respective merits of the party's position with respect to which party has the obligation to sort the yard waste. The city before yard waste, and that I'm capital Y, capital W, the city before capital Y, capital W waste is delivered to Vieste, or Vieste after capital Y, capital W waste is delivered, that dispute was not resolved in the arbitration." So the arbitration did not rule upon any of the issues that was presented to Judge Bergen, and Judge Bergen confirmed that when she ruled that, and this is in her July 20th, 2015, under advisement ruling, appendix page 138, she says, and I'm quoting, "He," referring to Judge Meyerson, "did not determine, nor was the issue before him, whether the city is required by the WSA to deliver only acceptable waste." And that's really what the core issue that Judge Bergen found in her summary judgment ruling is no, the city was not required to only deliver acceptable waste. And if it had been required to only deliver acceptable waste, it would have required, as Judge Bergen recognized, that provisions in the waste supply agreement would have to be ignored. It would ignore 2.4.1, it would ignore 2.4.2, which talked about what happens when unacceptable waste is delivered to the Vieste facility. And it wasn't a question, as Mr. Carey argued to you, about what the facility could process, because the facility was built after the waste supply agreement was executed. What really happened here is that Vieste, after entering into this waste supply agreement, understanding what the obligations were, understanding what the city's waste streams were, it designed a bad facility. It had a dispute with its designer and its the company that constructed the facility, because the equipment that it built and designed and put in the facility shredded the recyclables that it was trying to mine out of the city's typical municipal solid waste. And it's really when, in the operational phase, when the Vieste realized that it designed a faulty facility, that's when it tried to point the finger and shift the blame to the city. That's what this lawsuit is all about. And what Judge Bergen did on summary judgment was exactly what she was entitled to do, and exactly what the Arizona Supreme Court in Taylor dictates that she do. She looked first at the text of the waste supply agreement, and then she looked at the extrinsic evidence. And she admitted that extrinsic evidence that was consistent with and not contrary to the language in the waste supply agreement. And she even though she could have ignored Vieste's proffered evidence, which was solely, or essentially solely, Mr. Shelley's red line draft, she considered it. She considered it and found that that red line version for Mr. Shelley was not probative, because it did not support an interpretation of the waste supply agreement that it was reasonably susceptible of. She found that Mr. Shelley's email or red line draft did not answer the question that was before her, which is, even though Mr. Shelley recognized the issue about potentially sorting waste, he did not conclude or say that that was the city's versus Vieste's obligation. And perhaps most importantly, Judge Bergen recognized that there was nothing in the record that suggested that Vieste had ever seen Mr. Shelley's red line draft before the execution of the waste supply agreement. That language that Mr. Shelley drafted that was internal between the city of city of Glendale, that ever made it into the agreement. So although she considered it, she didn't find it probative and rejected it under Taylor. And I think finally, to answer your question, Judge Winthrop, as to why summary judgment was appropriate, Vieste did not provide any evidence that was admissible that supported an interpretation of the waste supply agreement that was reasonably susceptible of. Thank you.
Thank you, counsel. Mr. Carey.
Thank you. What happened here was Stuart Kent, their agent, manager, was asleep at the switch. If you look at our statement of facts at IR 282, paragraphs 99 and 207, it will show you he did not object to the exclusion of yard waste from the stream. And he was surprised he didn't remember that that was a provision of the contract. And so they just didn't know. But the reality, Judge Campbell, of what you were talking about is the homeowner grabs some yard waste. Let's just say it's yard waste under Exhibit B. They have some, and they have to drop it in a bin. They can either drop it in their curbside container or wait till the truck comes by. It doesn't become organic because you drop it in one and yard waste if you drop it in the other. That where you place it doesn't determine what it is. And the idea that yard waste is completely subsumed or synonymous with organics per yard makes no sense. And it's not, and there's no attempt to harmonize by Judge Bergen. And if you write it out, you're not only writing out and negating yard waste in Exhibit B, you're changing 1.1.54's definition of waste because you're writing out of that contract yard waste. And yard waste is a separate category from MSW and has to be given some meaning. I want to touch on very quickly the idea of the stream that can be pre-processed. The contract's crystal clear on this. If you go to 2.4.1, it says everything you deliver has to be acceptable. Waste means acceptable waste. In addition, meaning in addition to everything you bring to me, everything you deliver to me has to be acceptable. In addition, you can't pre-process that. So what can't be processed is not what they say throughout their brief, which is our typical municipal solid waste stream. That's not what it's talking about. It's talking about the waste stream that shows up at the facility, which is supposed to be acceptable. The contract allows for the vendor to take unacceptable waste, tip it, and put it off at its own cost, and that's only sensible because you're trying to do that. My time has expired. Thank you.
Thank you, counsel. I thank you both for your arguments this morning. We will take this matter under advisement and issue a written ruling in due course. We are adjourned.
I looked up at what? Somehow my clock skipped 10 minutes.
Right?